The Supreme Court chamber had never been this quiet. Every eye was locked on one woman, Congresswoman Jasmine Crockett, standing at the council's table, her voice steady, her hands calm, even as one of the nation's most powerful justices tried to shut her down. Justice Samuel Alito, a man known for his fiery opinions and thin patience, had interrupted her 3 times in 5 minutes. Each time, his tone sharper, his words colder. But this time she didn't flinch. Instead, Crockett opened a worn leather portfolio she'd kept closed until that exact moment. Inside was a single document, and what she said next didn't just silence the courtroom, it exposed a truth that would echo through the American legal system for years to come. Because within those 30 seconds, a sitting Congresswoman confronted a Supreme Court justice and changed the course of U.S. constitutional history. But how did a single exchange inside the nation's highest court manage to shake its foundations? And what exactly did Jasmine Crockett reveal that left even her critics speechless? Let's start from the beginning. To understand what made that moment so explosive, you have to know who Jasmine Crockett was and who she was standing up to. Crockett wasn't your typical politician. Before running for Congress, she'd built her career as a civil rights attorney and public defender, fighting for people who couldn't afford to fight for themselves. She'd spent years in courtrooms defending the right to vote, long before most of Washington even noticed how fragile it had become. On the other side of that courtroom sat Justice Samuel Alito, one of the most influential and controversial figures on the Supreme Court. Respected by conservatives, criticized by progressives, and never shy about sharing his opinions. In the months leading up to this case, Alito had made a string of public appearances that blurred the line between justice and politician. At one event, he'd questioned whether voting rights laws had gone too far, hinting that modern protections were unnecessary. Legal scholars called his comments reckless. Others said they exposed a deeper problem. Was the nation's highest court still impartial, or had it become another battlefield in America's political war? And that's what made this case so dangerous and so historic. Because this wasn't just another argument about voter ID laws. It was a constitutional showdown over who really holds power in America: the states that run the elections, or the Constitution that promises equality in every ballot cast. Crockett had come prepared for both the LA and the politics. But as the hearing began, few people in that chamber expected what she was about to do next. The doors to the Supreme Court had barely closed before the tension became electric. Every seat was filled with reporters, legal scholars, and civil rights advocates, all waiting to see how this unlikely showdown would play out. When Jasmine Crockett stepped up to the podium, the energy shifted. She didn't posture. She didn't rush. She simply began, "Mr. Chief Justice, and may it please the court." Her tone was calm, clear, and deliberate, the kind of voice that draws you in because you know she means every word. She opened by talking about the human cost of the case. 53,000 eligible voters, she said, were turned away last November in Jefferson County alone. This isn't about inconvenience. It's about whether those citizens ever get to be heard. You could feel the air tighten as she spoke. Then, just 90 seconds in, Justice Alito cut her off. "That's not what the Constitution says, Congresswoman," he said, his tone clipped and dismissive. "Your real quarrel is with the design of the Constitution itself." It wasn't just the interruption, it was the way he said it. He didn't call her counsel, he called her Congresswoman, a small break in courtroom etiquette, but a deliberate one. He was reminding her who held the power here. Crockett didn't blink. "Justice Alito," she replied evenly, "I'm not quarreling with the Constitution. I'm reading all of it." Then she went on, connecting Article 1 to the Reconstruction Amendments, the amendments written after the Civil War, to limit state power over elections. As she spoke, even some of the other justices leaned forward, intrigued. Alito interrupted again. "These are merely inconveniences, counsel, not constitutional violations," he said, his voice rising slightly. But Crockett didn't raise hers. "Respectfully, Your Honor, this court has already held that even without discriminatory intent, laws that disproportionately burden the right to vote must be justified by legitimate state interests." She cited precedent, named cases, and kept moving, her calm precision slicing through his objections like glass. By the time Alito interrupted a third time, his irritation was obvious. The audience could feel it, the imbalance of power shifting, slowly but unmistakably. And then, just as the courtroom began to hold its breath again, Crockett paused. She looked straight at him, and with absolute composure, she reached for the leather portfolio sitting unopened on the table. What she pulled from it would change the entire tone of the hearing and the future of voting rights in America. The room went still. No gavel, no whispers, just the echo of her portfolio snapping open. From inside, Jasmine Crockett pulled a single worn document, a relic of the nation's unfinished history. She looked directly at Justice Alito. "Justice Alito," she began, her tone calm but unyielding. "You've suggested both today and in recent public remarks that the original understanding of the Constitution gives states nearly unlimited control over voting procedures." A faint murmur rippled through the courtroom. "But I've taken the liberty," she continued, "of bringing the original record itself." The Chief Justice leaned forward. Even from the back rows, you could feel the shift. This wasn't a rebuttal. It was a revelation. Crockett held up the document. "This is a transcript from 1869, when Congress debated the 15th Amendment, the very amendment that defines federal authority over voting rights." She read, slowly and clearly. Senator Oliver Morton stated that the purpose of the amendment was to place the power of protecting the right to vote in the hands of the federal government, where it rightfully belongs. The words landed like a thunderclap. The courtroom silent. Justice Alito's expression tightened, his eyes narrowing as if trying to measure the weight of what had just been said. Crockett turned another page. Representative James Garfield, who later became president, said, "The time has come to establish a principle that overrides all state laws that burden the right to vote." Now even the clerks were exchanging glances. The history Alito had used for years to defend state control was being used to prove the opposite. "These are not obscure opinions," she said evenly. "They're the words of the framers themselves, the very architects of the Reconstruction Amendments, and they contradict the narrow interpretation this court has too often accepted." Justice Alito leaned toward his microphone, perhaps ready to push back, but Crockett wasn't done. "The Constitution," she said, "is not about granting authority. It's about limiting it, especially when that authority threatens the fundamental rights it was written to protect." Her voice didn't rise, but the power in it was unmistakable. You could almost hear the gravity of every syllable as she finished. "To ignore that history is not originalism, Justice Alito. It's selective constitutionalism." The line hit like a punch wrapped in velvet. Across the bench, several justices exchanged looks, not of partisanship but of recognition. Because what Crockett had just done wasn't political, it was foundational. And in that instant, everyone in the room, from the reporters to the justices, themselves realized that something irreversible had just happened. The argument was no longer about a single law. It was about the soul of the Constitution itself. The decision wasn't even out yet, but within hours of that argument, the country was already buzzing. Clips of Jasmine Crockett's calm takedown flooded every social feed, her words dissected frame by frame. Her composure replayed with captions like, "The moment the court went silent." News anchors called it the Crockett moment. Law professors called it a masterclass in constitutional judo. Because what she'd done wasn't just win a debate, she'd flipped the rules of the game. For decades, conservative originalists had claimed ownership over America's founding text. Crockett used their own method, the language of history and original intent, to prove that the Reconstruction framers had always meant for the federal government to protect voting rights. In one 20-minute argument, she'd turned originalism into a weapon for inclusion instead of restriction. Within a week, her written brief was being circulated in law schools nationwide. The Harvard Law Review announced a special issue dedicated entirely to her research. Commentators across the spectrum, from The Atlantic to National Review, admitted the same thing. Her evidence was airtight. Even critics who'd once dismissed her as a politician playing lawyer were now calling her argument the most disciplined constitutional research in a generation. But the public's reaction went beyond academia. In communities that had fought for ballot access for decades, Crockett's name became a rallying cry. Activists painted murals of her holding the leather portfolio. Voting rights groups saw record donations. And for many ordinary Americans who'd stopped believing their voices mattered, that courtroom clip felt like permission to hope again. Still, the question lingered: would that hope survive the court's final decision? Because if the justices sided with Crockett, it wouldn't just strike down one restrictive law, it would rewrite how every future voting case in America would be judged. And when the verdict finally came down, no one, not even her supporters, was ready for what happened next. 3 months later, the nation held its breath. Outside the Supreme Court, reporters stood shoulder to shoulder as cameras flashed and live streams rolled. The justices were about to release their ruling in Crockett versus Jefferson County, the most closely watched voting rights case in decades. When the opinion finally dropped, the headline stunned everyone: court strikes down voter restrictions in 6-3 decision. But that wasn't the shock. The real surprise came from who wrote the opinion: Chief Justice Roberts himself. And even more stunning, Justice Samuel Alito didn't dissent. The majority opinion opened with a sentence that echoed Crockett's argument almost word for word. When voting regulations result in clear disparities in access to the ballot, courts must apply heightened scrutiny to ensure that the right to vote remains meaningful. Roberts called it a return to the original promise of the Reconstruction Amendments. Alito, in a rare concurrence, admitted that the historical record illuminated aspects of the 15th Amendment that modern jurisprudence had overlooked. It was a quiet retreat, but a monumental one. Legal analysts were stunned. CNN's breaking banner read, "Crockett changes the game." NPR called it the most significant recalibration of voting rights in half a century. Even conservative scholars, though reluctant, admitted the decision had forced a reckoning not just with the law, but with history itself. In the space of one opinion, the court had done something unthinkable. It had adopted the very framework Jasmine Crockett laid out in that chamber. And in doing so, it didn't just affirm a right, it restored a constitutional vision that had been forgotten for more than a century. The verdict didn't just end a case, it ignited a movement. Within weeks, state legislatures across the country began reassessing their election laws. Bills that once passed quietly under the banner of integrity were suddenly being questioned under a new standard. Would this law actually protect the right to vote or just make it harder to use it? Civil rights lawyers called it the Crockett test. And soon, federal judges began citing Crockett versus Jefferson County as precedent in challenges from Georgia to Arizona. In less than a year, over a dozen restrictive voting measures were struck down not by politics but by constitutional principle. But the impact reached far beyond the courtroom. University students started forming Crockett Society's debate circles, dedicated to re-examining America's founding documents through a lens of inclusion. Law schools that once treated voting rights as a niche elective now had full courses dedicated to the case. Even in Congress, the tone began to shift. Lawmakers from both parties, though for different reasons, cited the case in floor speeches about restoring public trust in democracy. For once, the word bipartisan didn't sound hollow. Meanwhile, Justice Alito's reputation took an unexpected turn. After months of silence, he gave a rare public lecture at Georgetown, where he said something no one expected. The Constitution is not static. It's an argument between the living and the dead. And sometimes the living win. It wasn't an apology, but it was acknowledgement. And at the center of it all, Jasmine Crockett became more than a name, she became a symbol. A symbol of what happens when conviction meets preparation and truth meets timing. Late-night shows replayed her quotes. Young women in law school cited her as the reason they applied. And for the first time in years, millions of Americans began to believe that maybe, just maybe, the system could still work, if someone brave enough challenged it. But as the momentum grew, so did the backlash. Political operatives began calling her victory a partisan stunt in disguise. Anonymous leaks hinted at internal conflicts within the court. And just when it seemed like the movement was unstoppable, a new controversy surfaced that threatened to unravel everything she'd built. Years later, people still talk about it not just as a case, but as a moment that reset the nation's moral compass. In classrooms, law schools, and community centers, The name Crockett vs. Jefferson County isn't just studied, it's felt. Because it proved something most people had quietly stopped believing. That one voice, armed with truth and courage, could still move the needle of history. For Jasmine Crockett, the legacy wasn't the fame or the headlines, it was the change. She often said in interviews, "I didn't want to win an argument. I wanted to remind this country of what it promised to be." Her ruling reshaped how courts view the right to vote, but it also did something deeper. It reminded Americans that the Constitution isn't a relic. It's a living pact, fragile, imperfect, but alive only if people are willing to defend it. Justice Alito would retire a year later, quietly, without comment. But in his final speech from the bench, he quoted something Crockett herself had said during the hearing. "The Constitution isn't about control. It's about conviction." He paused, then added, "And conviction is what keeps this country alive." That moment, brief, understated, and unrecorded in the official transcript, said everything. Because in the end, this wasn't a story about politics or even law. It was a story about power, truth, and the rare kind of courage that changes both. And whether you agreed with her or not, Jasmine Crockett did something almost no one in modern politics can claim: she made the country listen.